Good afternoon, everyone. We'll come to order now. This is the Indigenous and Northern Affairs Standing Committee of the House of Commons, and today we're convening pursuant to Standing Order 1082, study of subject matter of Bill S3, an act to amend the Indian Act, specifically the elimination of sex-based inequities in registration. And today we're meeting, as we always do, on unceded Algonquin territory, and we're very grateful for that. We have a very packed panel for the first hour, so we've asked our 5 speakers to limit their remarks to 7 minutes each. That will then leave 25 minutes for questions from the committee itself. I have here these 2 cards, and for each speaker, when we get to the 6th minute, I'll wave around a yellow card so that you know you have a minute to conclude, and then a red card and to finish up. And I would ask you to do your very best to stay within that time limit so that we can make sure that we get some questions and that everyone can be heard fairly. So without further ado, I'd like to introduce this panel of speakers. First, from the Canadian Bar Association, welcome Gayleen Schellenberg, lawyer, legislative and law reform. David Taylor, executive member of the Aboriginal Law Section. From the Women's Legal Education and Action Fund, Kim Stanton, the legal director. Krista Nerland, associate, Olthius Clear Townsend LLP. And appearing today as individuals, Pamela Palmater, Chair in Indigenous Governance, Ryerson University, Department of Politics and Public Administration. Also appearing as an individual, Mary Eberts and Ellen Gabriel. Welcome to you all. We're very pleased that you could join us for today, and we will launch right into the first speaker, which is the Canadian Bar Association. With the 2 representatives, I invite you to share the time between you as you see fit within those 7 minutes. So you've got the floor. Thank you very much.
Thank you for the invitation to appear before you on Bill S3 today. The Canadian Bar Association is a national association of over 36,000 lawyers, law students, notaries, and academics, with a mandate that includes seeking improvement in the law and the administration of justice. Our Aboriginal Law Section consists of members specializing in Aboriginal law from all parts of Canada, and with me today is David Taylor, an executive member of that section. David will will summarize some of the highlights from our brief and respond to your questions. Thank you.
Good afternoon, and thank you, Mr. Chair, honourable members. C'est un plaisir de comparaître devant le comité.
It's a pleasure to appear before the Standing Committee for Aboriginal Affairs and the North. Our presentation will be in English, but I would be pleased to answer any of your questions in French.
Pleased to contribute to the Standing Committee on Indigenous and Northern Affairs pre-study of Bill S3's subject matter. I would begin by recalling the words of Madam Justice Ross of the Supreme Court of British Columbia in her reasons at trial in McIver versus the Registrar, Indian and Northern Affairs Canada. It is one of our most basic expectations that we will acquire the cultural identity of our parents, and that as parents we will transmit our cultural identity to our children. It is therefore not surprising that one of the most frequent criticisms of the registration scheme is that it denies Indian women the ability to pass Indian status to their children. One of our main points concerns the manner in which this bill was brought forward and is being considered by Parliament. When Bill S3 was introduced at first reading in the Senate, consultations with regard to the first phase of the government's response to the Deschanel decision were far from over. While we understand that the Indigenous Affairs consultations regarding Bill S3 were to conclude last Friday, December 2, it remains the case that moving forward in the legislative process, while there were still consultations underway, undermines the fulfillment of the federal government's duty to consult Indigenous peoples regarding legislative changes that affect them as required by the Honour of the Crown and the United Nations Declaration on the Rights of Indigenous Peoples. While the committee stages in the Senate and in the House are designed for the amendment of bills based on public feedback, the Honour of the Crown and the United Nations Declaration require more than Indigenous peoples being left to watch the legislative train leave the station. We are also concerned by Clause 8 of Bill S3, which precludes those impacted by Bill S3 from seeking compensation for their past exclusion from Indian status. Parliament and the Federal Crown have been on notice since at least the Court of Appeal for British Columbia's 2009 decision in McIver that the 1985 amendments to the Indian Act did not entirely resolve the discriminatory aspects of the Indian status system and in fact created new discriminatory elements. On this point, Madam Justice Moss held in Deschanel that the year is now 2015. The 1985 Act from which the discrimination arises has been enforced for a little more than 30 years. The general finding of discrimination in the 2009 judgment of the Court of Appeal for British Columbia in McIver could have enabled Parliament to make more sweeping corrections than what was accomplished in the measures in the 2010 Act. The discrimination suffered by the plaintiffs arises from the same source as the one identified in that case. Canada was aware that work remained to be done following McIver and Bill C-3. Leaving Clause 8 in Bill S-3 immunizes Canada from the consequences of its conduct and provides little incentive to ensure that the eradication of discrimination in the context of Indian status proceeds without delay. By continuing to withhold eligibility for Indian status from certain women and their descendants, government realizes a cost saving, controlling costs by having fewer members. The result of discrimination should not be an economic benefit to the government. Removing Clause 8 from Bill S-3 will change the financial incentive going forward and would send a clear message from Parliament that the government will not be given a license to discriminate through absolution for the past consequences of its actions, where government was clearly on notice through prior court decision that its broader legislative scheme was not on sound constitutional footing. As a practical matter, sufficient resources should be provided to bands that will see an influx of new members as a result of Bill S-3, and sufficient resources should be provided to the relevant operational sectors at Indigenous Affairs in order to ensure that the registration of individuals who have been unconstitutionally excluded for more than 3 decades proceeds with all due dispatch. The subject matter of Bill S-3 should also be referred to a parliamentary committee within 18 months of its coming into force. We understand that the government is committed to proposing further revisions to the Indian status system as part of its 2-stage response to the Deschanel decision. This is to be commended and is in keeping with Justice Mass's calls for a broader review of this question. Indeed, in the second last paragraph of her reasons for judgment, Madam Justice Mass held that Parliament should not interpret this judgment as strictly as it did the Court of Appeal for British Columbia's judgment in McIver. If it wishes to fully play its role, instead of giving free rein to legal disputes, it must act differently this time, while also quickly making sufficiently significant corrections to remedy the discrimination identified in this case. One approach does not exclude the other. Given the long history of discrimination involved in the Indian status system, the Stage 2 process will benefit from timely parliamentary scrutiny, long enough before the next election to ensure that parliamentarians' expertise and the views of community members do not get lost in the legislative crunch that accompanies the end of a parliamentary session. In closing, it is important to note that the McIver and Deschanel decisions deal with aspects of the Indian status system that are discriminatory, contrary to Section 15 of the Charter. As such, they set the constitutional floor, the level of fairness below which the Indian status system may not fall. Certainly, the legislative process, both here and in the phase to come, should set its sights higher in an attempt to rectify the inequities that have long been identified in the Indian status system. Those are our submissions. Thank you. Merci.
Thank you very much, Mr. Taylor. We'll move right along to the Women's Legal Education Action Fund, again to share the 7 minutes between Ms. Nerland and Ms. Stanton as you would like.
Thank you. Good afternoon, and thank you so much for inviting LEAF to speak with you today. And thank you, we're very grateful to the Algonquin Nation for allowing us to meet on their territory. My name is Kim Stanton. I'm the Legal Director at LEAF, the Women's Legal Education and Action Fund. And with me is Krista Nerland, with Olthus Clear Townsend. Krista is LEAF's co-counsel in its intervention in the Gale and Attorney General case. This is a case that's making its way to the Ontario Court of Appeal for a hearing in a couple of weeks' time. It's about the way the Indian Act treats unstated and unknown paternity, and we say is a form of sex discrimination against women. That policy, we note with concern that the Department of Justice continues to fight Dr. Gale, an Indigenous woman who lives with a disability, in her efforts to gain status. That is something that we really do need to rectify, and this bill doesn't do it. LEAF is a national organization. We're a nonprofit. We were founded in 1985 to promote substantive equality for women and girls through litigation, law reform, and public education. And we've been long concerned about the persistence of sex discrimination in the Indian Act, and we're very disheartened that this is yet another legislative attempt to address the discrimination that falls short of providing Indigenous women with justice. Krista will provide you now with a summary of our concerns about this bill.
Thanks, Kim. LEAF is focusing our submissions today on what the government calls Phase 1, essentially Bill S-3 before you. LEAF supports the broader nation-to-nation conversation about moving beyond Indian Act status towards First Nation citizenship that will follow. But in the meantime, it's our position that it's not acceptable to leave in place a status regime that discriminates against Indigenous women. With that in mind, we'd like to make 5 basic points about the bill to you today. First, the Native Women's Association of Canada, I think, has already explained to this committee that Indigenous women were left out of the development of this bill and that it was presented to them as a fait accompli. This is a mistake. It should go without saying that Indigenous women's groups should be partners in remedying sex discrimination against Indigenous women under the Indian Act. Second, contrary to its title, this Act does not remove or eliminate all the sex discrimination in the Indian Act status provisions. It's at best a partial response. For example, the bill seems to allow for the granting of lesser status to certain people born prior to 1951 who trace their Indian status through the female line. And in addition, the status provisions, or actually more particularly the way that INAC implements them, impose a disproportionate burden on women who cannot identify the father of their children, for instance, because of rape, incest, or domestic violence. And it leaves those women and their children without equal access to the status provisions under the Act. This is sex discrimination, and it's prohibited by both Section 15 of the Charter and by international law. In our view, S3 is an unfortunate replica of the narrow, piecemeal approach that Parliament took 6 years ago after the British Columbia Court of Appeals decision in McIver. If this bill passes as it is, we'll all be back here in a year, or in 2 years, or in 5 years, as another Indigenous woman or one of her descendants has spent years before the courts trying to get equal access to status under the Act. It's unacceptable, and it's inconsistent with the Charter's substantive equality guarantee to force Indigenous women and their descendants to endure the financial and emotional hardship of years of protracted litigation to address discrimination that we already know is in the Indian Act. LEAF urges this committee to ensure Parliament's legislative response to Deschanel removes all sex discrimination from the status provisions now. This will be a strong foundation for the broader nation-to-nation conversation about moving beyond the Indian Act that follows. Third, the best way to do this is to stop creating layers and layers of status that leave intact the old discrimination under the Act. There are better options. 6 years ago, after the decision in McIver, the government proposed a similarly narrow and piecemeal reform bill, not unlike the one before you today. And at the time, an amendment was put forth that effectively gave everyone status under an amended form of Section 61A, rather than creating more and more layers of inferior status. A provision like that would go a lot further to addressing the sex discrimination in the Act, although it's worth noting that this would not address the discrimination against women who cannot or will not state the paternity of their children. So that's something that needs to be addressed in addition. Fourth, the Quebec Superior Court's deadline of February 3rd, 2017 should not be relied on as justification for a bill that doesn't do the job. If you can't remove all the sex discrimination now, then you need to ask for an extension in order to ensure that the bill addresses, as it goes through, addresses all of the discrimination that we know to be in the Indian Act. And finally, LEAF urges the government to ensure that First Nations communities and organizations have both the land and the resources they need to support new registrants. What this means can't be determined unilaterally in Ottawa, but it needs to happen in partnership with those First Nations governments and organizations. By way of conclusion, I just want to emphasize to you what's at stake for the people who are excluded from status as a result of these discriminatory provisions. It's not just about the material benefits, post-secondary funding, health, although those can be significant. Being denied status can also mean exclusion from community life, denial of human dignity and self-worth, loss of band membership and the ability to live on reserve. And the United Nations Committee on the Elimination of Discrimination Against Women has stated that these provisions in the Indian Act are among the root causes of violence against Indigenous women in Canada. These harms are serious, and Indigenous women and their descendants have already endured them for over 145 years. It's essential that the government get this bill right. Thank you for allowing us to make submissions.
Okay, thank you very much for that. Before we move to Ms. Palmer with speaking as an individual, I just want to note that Ms. Palmer provided us with a handout. We didn't have time to get it translated into both official languages. We have it in English and a draft in French. If it's okay with the committee, we'll pass that out, but I didn't want to do that without permission. Does that sound okay to everybody? Okay. Yeah, if you wouldn't mind passing it up, that's great. Okay, Ms. Palmer, the floor is yours for 7 minutes. Thank you.
Kwe, Nindaluizi Pam Palmater. I'm from the sovereign Mi'kmaq Nation on unceded territories in Mi'kma'ki. I want to thank you for allowing me to come today to speak to some of my concerns with Bill S3. But first, I think it's important to acknowledge that we're on Algonquin territory, and second of all, the reason why we're here today. If it weren't for the efforts of Indigenous women who have continued this battle for many decades, like Mary Tu Axe Early, Jeanette Corbière-Laval, Yvonne Bedard, Sharon McIver, Sandra Lovelace, and now we're into the second generation of litigants fighting for gender equality for Indigenous women, including Jeremy Matson, Lynn Gale, Nathan McGilvery, and of course, Stéphane Deschanel. My primary concerns are, they will be laid out in the submission that is being handed out. One, and the most important one, is that Bill S3 does not address all known gender discrimination. It doesn't. You've heard from other witnesses that have given very specific examples. My examples are not exhaustive, but they include grandchildren who trace their descent through Indian women who married out pre-1951, the illegitimate female children and their descendants who trace descent from Indian men born pre-1951, and also the differentiation and hierarchy that was created between Section 61A, the male category, and Section 61E, or Section 61C, primarily the female category. They have come to be known as the real Indians and the wannabe Indians. And in fact, 61C are the same in descent. There just happen to be Indigenous women and their descendants. Also a problem that also causes gender discrimination is with Bill S3, they've now included even more complex and differentiation in terms of categories. You have 61 C.01, C2, C3, C4, and this also disproportionately impacts the descendants of Indian women who married out. And here's the problem with that. There is no legal or policy justification on behalf of Indian Affairs to have everyone identified in this way. Programs and services are addressed through contribution agreements based on a membership or the Status Indian Registry. They never have to record whether you get health if you're a 61A, B, C, D, E, or F, or 6-2. So there's no justification for it. So then what's the alternative reason for it? And what it does is it places a scarlet letter on women and their descendants for having committed the sins of marrying out, having had illegitimate children, or worse, being born female. And that's a scarlet letter that doesn't attach to Indian men and their descendants who have married out and intermarried for many successive generations. The other issue is the hierarchy of Indian status between Section 6.1 and 6.2, those who can pass on status and those who can't. Those in the who can't section are somehow seen as defective and cannot pass on their status to others, and it disproportionately impacts Indigenous women. The children of unwed Indian mothers who cannot name the father or who will not name the father because of the reasons that Leif annotated, and also when fathers deny paternity or when they refuse to sign application forms. INAC has given the power to Indian men to impact the children of Indigenous women this way. And then lastly, the denial of compensation to women who have suffered discrimination for so long. Bill S3 also does not provide adequate protection for membership. You'll recall pre-1985, Indian status and membership is synonymous. Even after S3, it'll only be synonymous for Indian men, not for Indian women. C3 didn't provide those protections, now S3 doesn't provide those protections. The constitutional protection for gender equality is just that. Section 15 of the Charter is equality for men and women. Section 35(4) of the Constitution, for anyone who wants to exercise Aboriginal treaty rights, must be guaranteed equally between men and women. Article 44 of UNDRIP, which this government has said is going to implement, also says equality between men and women. There is no legal option to negotiate, consider, consult, or agree our way out of gender equality. And if you look at the traditional laws of Indigenous nations in this country, I have yet to find one in all of my research that promotes through their laws gender inequality. Canada cannot proceed on to phase 2 without addressing all gender inequality. It acts as a legal prerequisite. You cannot talk to our First Nations without our Indigenous women and their descendants there. It is unconstitutional, it violates all of our traditional laws, and it would act as a legal barrier to even starting the conversation in phase 2. Bill S3 also needs to be accompanied by funding for First Nations. You'll know that INAC set aside millions of dollars for itself to deal with S3 applications, but it didn't set aside a single cent for First Nations to deal with this at the community level. Canada obviously failed to engage in any sort of legal consultations by their own admission. And the impact of Indian registration, as we discussed, is very serious. It's not just about programs and benefits. It's a root cause of murder to missing Indigenous women. It's lack of access to elders, language, ceremonies, even access to powwows. There are powwows where children cannot attend unless they have a status card, no matter how they were raised or if they were even raised in a First Nation community. It also won't address any of the pending litigation. Sharon McIver's litigation is still outstanding. The Deschanel has cases that are in the hopper. Lynn Gales, Jeremy Matson's, Nathan McGilvery, Canadian Human Rights Commission has many. And of course, there's the Bill C3 class action that was brought about because of the gender discrimination. So my recommendations very quickly, 6(1)A all the way. Every Indigenous man and woman who had children prior to 1985, married or not, all get the same kind of status so that Indigenous women and their descendants don't have to wear the scarlet letter of Section 6(1)C. You need rightful compensation for those who have been knowingly denied gender equality since 1982. Pre-1982, Justice said that's a barrier. Legal consultations, and my last sentence to you is, if we do not address gender discrimination now, in all likelihood it won't happen. Phase 2, they want us to deal with Aboriginal treaty rights, nation to nation, getting rid of the Indian Act, and her standard for that, the minister testified, is absolute consensus. There will never be, in the history of humanity, consensus on gender equality, but that's the law of the land. Thank you.
Thank you, Ms. Palmater. We'll move right to the next speaker, Mary Eberts, please.
Thank you very much. Thank you for inviting me, and I also offer thanks to the Algonquin Nation, which hosts us all on its territory. I have been counsel to, in many cases where women or women and their children have sought to challenge the denial of status under the Indian Act. I have also made representations to this House and to the Senate on behalf of the Native Women's Association of Canada and on behalf of Indian Rights for Indian Women on the issues relating to registration and women. On this occasion, I appear as an individual, and I do not speak for any client. I would like to add some recognitions to those offered by Dr. Palmateer. In the Deschanel case, 2 other plaintiffs were also women, Susan Yantha and her daughter Tammy. They challenged the inability of a woman to pass on her status to a child born out of wedlock in certain circumstances. I would also like to recognize or complete the recognition to Mary 2 acts early by recognizing Jenny Margetts and Nellie Carlson, who helped found the Western branch of Indian Rights for Indian Women. I have 2 points to make today. Bill S3 is under-inclusive, and the process being used for amending the registration provisions by way of Bill S3 is not in accordance with the recommendations of Madam Justice Mass. I begin with some comments on the origins of discrimination against women, which I ask you to bear in mind as you consider whether to endorse a narrow approach to remediation of this law, as has been installed in S3, or a broader approach to remediation of the law, as has been recommended by Dr. Palmatier, Sharon McIver, and others. It's crucial to remember that one of the main purposes of the Indian Act was to hasten the civilization, meaning assimilation, of Aboriginal people. One of the primary mechanisms for achieving assimilation was the definition of Indian included in the Act. Anyone not within that definition was, because of that exclusion, assimilated. That is no longer the responsibility of the Government of Canada. Why was this done? We should never forget. Even when there was a treaty about land, the First Nation was assigned its land and the land was administered under the Indian Act. The connection between Indian land and the Indian Act has a key consequence. If the number of status Indians could be reduced to 0, then the connection between Aboriginal people and their lands would be severed. There has always been a link between the disentitlement of women from conferring status in their own right and the coveting of Indian land. Historically, women were the primary targets for exclusion from the Act. One reason for this was the male privilege which reigned supreme in the Victorian era when the Act was first conceived. Another was the willingness to override Indigenous laws about membership. These two reasons acted together. The Indian Act enforced the Victorian family with its paterfamilias, overriding the rules of many Indigenous cultures which had the woman as the source of membership in the nation. For example, the Tsimshian stick law provided that a woman and her children were always members of the nation, welcome back even after they had separated from it through marriage or for other reasons. The one exception to this male hegemony over status was the right of the Indian woman to confer status on a child whom she bore out of wedlock. This was not an unqualified right. It was possible, under many versions of this legislation, for the child's entitlement to status to be challenged. When the case of Martin v. Chapman held that a male Indian could also confer status on his child, namely his son, born out of wedlock, that right did not carry with it any possibility that someone could protest that the father was not an Indian. This, too, is a sign of disproportionate power for the male under the Indian Act system. Simple acknowledgement of the child as his own, whether or not that it's true, would confer status on the child. In the unstated or unacknowledged paternity rules under the present Act, we see a powerful restatement of this male privilege, where withholding that acknowledgement, or the impossibility of getting it, prejudices the child's acquisition of full status. Each time reform of the Indian Act holds back on giving full rights to women, either in the present day or vis-a-vis past rules, we are perpetuating the system that used disinheritance of women and their children as a tool of assimilation. If we continue this assimilationist approach in the construction and administration of the Indian Act, we are continuing the approach of the colonizer, so well summed up in this statement by Duncan Campbell Scott, then Deputy Superintendent of Indian Affairs. He said this in 1920, "Our objective is to continue until there is not a single Indian in Canada that has not been absorbed into the body politic, and there is no Indian question and no Indian department, and that is the whole object of this bill." Let me mention some areas of under-inclusiveness. One, let me begin by saying I agree with Dr. Palmatier and Sharon McIver about the practicability and the wisdom of 6.1a as amending 6.1a for all purposes. I also agree with the CBA in its recommendation about Section 8. And I would refer you to the brief of the Grand Conseil de la Nation Wabanaki for some further instances where Bill S3 does not fulfill its mandate. If I may, one last point about consultation. I agree with the witnesses who have said that consultation is not appropriate in a case where you are remediating violations of equality rights. The Bill C-31 was the product of consultation, and we see now, 30 years later, people are still litigating the unconstitutionality of what that consultation produced. Thank you.
Thank you very much for that. Ms. Gabriel, if you'd like to proceed right into your 7 minutes.
Okay.
Thank you.
Sego wat kun waratus katitsago snayo jats tanawa ganyato kanyaka kana ganyato tanu kana sataga na kana gere tats tanu warata na sungwe tats jaja sewan sarata awan tin gwana gere na kanya te nistan hotsa tanu te tin waratus na yete nistan hotsa tin gwa kun hota yung kiawis tanu wat kun waratu sa gwa ku te tawana. I greet you in my language and acknowledge all the life forces, the natural life forces that allow us to be here today. Including Mother Earth. And I've been listening to people talk about the legalities of it, and I'm here to tell you a bit what it's like to live in a community where there's fighting over who's more Indian than the other person. Because we, as Indigenous people, are regulating Canada's dysfunction, Canada's refusal to repudiate the doctrines of superiority that have allowed Canada to tell us and define us who is going to be an Indian under the Indian Act. You come to us and you expect us to give you the answer. Well, the answer is self-determination. Not self-government, but self-determination. And I agree with everything that has been said today. Indigenous women have experienced double discrimination, first for being Indigenous and then for being a woman. And I find that a lot of the semantics that are being used in the propaganda to sway people to think that they are getting any kind of entitlement if you have status. I think it belies the dispossession that we experience as Indigenous people to make us think that we're entitled to this, something that our ancestors gave us. We're entitled to that from the colonizer. Well, we're going to be rebuilding our nations. And just like the Indian residential school apology acknowledge those who survived the genocide, Canada needs to acknowledge as well and go further and deeper. And the damages and threats to our languages and culture, criminalizing our traditional forms of governance. Our traditional forms of governance need to be re-emerging and be part, not a so-called consultant, but a true partnership as a nation, because we are always considered minorities. We are not minorities. We are peoples with self-determining rights, and as such, we will determine who will be our citizen. And forced assimilation, as Mary was talking about, Article 8 of the Declaration. Indigenous people and individuals have the right not to be subjected to forced assimilation or destruction of their culture. But yet that is exactly what is going on with Canada and its laws. As Mary has said, 1985 was exactly when we started getting some movement on this, but Canada has been hesitant because of the cost. And what happens in our communities is that we are being further dispossessed, because it always is in the public interest, not Indigenous people's human rights interest, that goes first. And so we are the first to experience climate change. We are the first to have less than what the ordinary Canadian considers. As the Auditor General, Sheila Fraser, said many years ago, it would take 28 years for in-community schools, imagine that, schools are going to be set aside, 28 years for us to catch up with the rest of the schools in the rest of Canada. That is the kind of portrait that I want you to see what you are going to be deciding about. We need to have the emergence and the ability to recover from the genocide that our ancestors recovered from. Canada must repair the harm that it has done to Indigenous nations. And why do we always have to take up residency on reserves, these small postage stamp size communities that the government of Canada has allowed us, out of the good graces of their heart, for us to live on, and yet they can appropriate the land any time that they feel like it? So I find it really, really difficult to be here and to talk about gender equality, because I do believe it. I wholeheartedly believed in gender equality. But there must be some reconciliation and restitution. There must be a human rights-based approach. And the United Nations Declaration on the Rights of Indigenous People is a good way to go about it. Universal, interdependent, indivisible, those are what human rights are about. It's not about the economics of it. And Canada needs to stop making us their industry to make employees and to create jobs, because a lot of our budget goes to the bureaucracy that's in the Department of Indian and Northern Affairs Canada. The consultations are totally inadequate. You have to have real consultations here. If we are going to profoundly address this issue of gender equality, we have to put this aside of what it's going to cost Canada, because it's now costing us. It's costing us threats to our language, threats to our culture, threats to our land, the environment. And I really, I find it really difficult to hear about the Prime Minister of Canada saying that Indigenous people are the most important relationship that he has, when I see what is going on in the environment and the pipelines, and the fact that my community, who suffered military occupation and paramilitary forces 26 years ago in my community, are still struggling with the same land issues that we were back then. Ours is the oldest issue. The 300 years it's going on. So we need to stop looking at the cost, and we need to start looking at the traditional customs. And we need access to our 1886 trust fund that was developed for us. That's where our money for the services comes from. And when Canada decides to accept someone as a citizen, that citizen has to study about what their kind of country, they're going to speak their language, they're going to speak, understand their culture. That doesn't happen when it comes to Indian status. Indian status is given out like bingo cards. And we want those people, if they are going to come back, that they are going to also learn their language, they're going to learn their culture. And that it's not about going to the SAQ and buying bottles of wine without not paying taxes. It's about something more profound than that. That it's about being ukwahuwe, the real human beings that my ancestors talked about, and loving the land, loving the environment, and thinking for 7 generations ahead. That's what this should be about. So I thank you for your time, and I mean no disrespect to anybody. I hope my words did not offend anyone.
Thank you very much, Ms. Gabriel. We'll go right into a round of questions from the members. Each question is similarly 7 minutes, and I'll use the cards the same way. And the first question is coming from Gary Anandasangri, please.
Thank you, Mr. Chair, and thank you to the panel for your very candid assessment of the S3. And we certainly take no offense. Ms. Gabriel, you remind us of the reasons why we're all here, especially as MPs, in order to work on such an important issue. I'm a little conflicted, I must admit, and I'm going to, because we have very limited time, I'm going to really be very specific on my question, and I want to be able to yield some time to my colleague from Thunder Bay. But in the time I have, I want to ask each one of you, the 3 organizations, as well as the 2 individuals that are appearing, specifically this question. As we see S3, do we pass it, and with the commitment from the Minister and the Department to go into phase 2 consultation, or B, amend it, and if we amend it, what are the specifics that, I know you've all mentioned it, but if you can just give us very specific points, and 3, not amend it and just go into phase 2, knowing full well that it will be in violation of the ruling. And I know it's probably a difficult position to put you on, but I think it'll be helpful for us as we deliberate.
I guess to start, to the extent that other discrete categories have been identified and are known, the bill's title is to end, known gender discrimination. Then the approach would be to amend the bill now with what else is on the table. There have been a variety of proposals as to how best to do that, and the CBA won't take a position on which that is. There's further adding the different criteria in, or as Dr. Palmater has proposed, the amendment to provide 6.1a status going back before 1985. But certainly to the extent Parliament knows now that there's an issue, the thing to do is to act now, like Justice Mass encouraged at the end of her reasons, not to limit it only to the facts of the Deschenaux plaintiffs.
Thank you. So we agree that it should be amended now. It should not be passed. It should not be left to phase 2. It needs to be fixed now. And to the extent that an amendment can encompass what Dr. Palmater has suggested in terms of 6.1a for everybody, we certainly agree with that. We want to see that hierarchies are removed from the Indian Act. This bill perpetuates hierarchies. Those need to be removed. And we certainly don't think that the bill should be passed as is at all. It needs to be amended.
I agree. It needs to be amended. My caution on that is it should be amended to make sure that men and women, married or not, and their descendants are equal pre-85 under Section 6.1a, so that there's no hierarchy. However, this was attempted before with the McIver in Bill C3, and that amendment was ruled out of order for procedural reasons. If it comes up that there's some technicality or procedure that doesn't allow you to do that and you can't amend it properly, then an extension should be sought from the court with the consent of the Deschenaux litigants, which they've already given, to allow further time to go back and get it right and not leave it for phase 2, because phase 2 has that standard of consensus, and as you know, no human society ever agrees on gender equality, and we don't have the option to do that.
Thank you. And very briefly, Madam.
I agree with Dr. Palmater virtually entirely, and would add this, that if amendment amounting to making everyone a 6.1a is challenged, my own view is that it's highly arguable that such an amendment is valid, because the title of the Act, therefore the purpose of the Act, is the elimination of sex-based inequities in registration. That is a broad purpose, and I would encourage you to be bold given that broad purpose. Thank you.
I agree with the previous speakers. I think if you're going to do any amendments, it has to be with the free, prior, and informed consent of Indigenous people. The Canadian Human Rights Commission and I believe the Supreme Court has said that, the Canadian courts are free to use international human rights instruments when interpreting domestic legislation, and you should be bringing in those international human rights instruments into this discussion.
Thank you very much, Mr. Chair. I'd like to yield my rest of the time to my colleague from Thunder Bay.
Very good, Don. 2 minutes remaining.
So, Ms. Gabriel, what you said in your 7-minute presentation really spoke to me, because I think it's what we need to be doing at this committee. What we need to be doing as a government is the Indian Act is something that was designed to destroy our people, and tinkering with it or doing certain things to it does nothing to move our people forward. We're just perpetuating all the problems that have existed in our communities for far too long. But having said that, I know I speak, or I've worked in many isolated First Nation communities, people that have absolutely been destroyed by the Indian Act, that are absolutely dependent. And I've asked this question of department officials, and I'm assured the committee will get the answer on who are these 35,000 people or 40,000 people that the minister said today are going to be affected by S3, and who are the potential people that may be affected by certain amendments. And then I ask myself, there's a finite set of resources within the Department of Indian and Northern Affairs. So are these people that currently are under the Indian Act, that absolutely depend on the Indian Act, going to be affected by a resourcing problem if more people are admitted for status under the Indian Act?
I'm afraid there are just about 20 seconds remaining. I'm not sure, Don, who you wanted to respond to that.
I'd like to respond. Or sorry, you want to? Okay.
Most definitely, the funding is going to be an issue, and I think that the You know, the Department of Indian and Northern Affairs should not take so much for the administration costs, because we need the funding. We need to rebuild our nations, and if there's going to be real reconciliation, there needs to be restitution. Restitution costs money, unfortunately, and rebuilding from genocide costs money. So.
I'm afraid we're out of time there. I'm sure there'll be an opportunity to get some of the other elements of the answers. In latter questions, Kathy McLeod, please.
Thank you, Mr. Chair. Thank you to the witnesses. Back on November 21st, we had officials from the department here, and I asked them if they were confident that we have taken care of this as an issue, in terms of the title and dealing with all gender-based inequities. And what they indicated was that they were absolutely confident with these amendments. We were dealing with all known sex-based inequities in Indian registration, end quote. It's become very clear very quickly that this is not the case. So I guess there's a few things. I agree that when there's human rights issues that you have to, we talk about consultation, but I think consultation in terms of the experts. I mean, what we've learned from every witness who's identified, different problems. So I see in some ways a different sort of process that the government must do to make sure that what gets presented, what amendments are made, have really had the look from people that are experts such as yourself. So, having said that, what I have recommended and proposed, although my Liberal colleagues don't want to support that, is phase 2 should be left for big picture issues, that we need to get this piece of legislation right. I am not confident. I mean, we could scramble a few amendments forward and maybe throw it through, but I think we're going to be back dealing with the same issue. So I'm not saying we should have a long time, but I think they should ask for an extension, have the dialogue with people that can really make sure that they're identifying any other issues, and then move forward. Otherwise, we'll sit for another 5-6 years. So I would invite everyone to comment. Do they believe that that is probably the best approach to make sure this legislation is right?
I agree with your suggestion. I've been a litigator for 40 years now and counting, and often appearing in court against the Government of Canada in cases where the construction of the equality guarantees in the Charter is at issue. And I can tell you that the Government of Canada, historically, since the guarantees were put into the Charter in 1982, has taken a very, very conservative approach about what they mean and what they guarantee. And so it is very useful to have a process which lets the light in and which opens that up. And it doesn't wait for court to happen. That they must take a broader approach to the guarantees of the Charter. And I agree there should be time to do that. And it's not something that should be dealt with in a big picture consultation. It's nitty-gritty, it's technical, and it needs to be dealt with as a set of technical amendments informed by the substantive guarantees of the Charter.
I agree. This is the third time around now dealing with gender equality, and Justice of Canada and the Minister testified in Senate, in the other place, that in fact they know that it doesn't deal with all gender discrimination. They testified otherwise, but they have now since testified they know that what they're dealing with is simple gender discrimination instead of complex. The complex meaning we have multiple layers of discrimination on us as Indigenous women, and that shouldn't be dealt with. So they should definitely get an extension from the court, which they've got in MacIver twice, no problem. The court seems very willing for Canada to go broader and deal with gender discrimination. And had they consulted back on August 15th when this decision was handed out with First Nations and Indigenous women, we could have all told them these problems, but they didn't tell us and they didn't consult, and that's why we're here using the election as an excuse. Well, their processes do not detract from our equality rights. And none of the bureaucracy and the very officials that were testifying here are the same ones that have been working on this for decades. They weren't in an election. It was just the minister. So they have no excuse not to do this right, and we now know that there is a problem. They've admitted there's a problem, so let's just deal with it. Phase 2, yes, we should be talking about the conversation about whether they should be doing status at all and getting out of our business and us being self-determining like they promised under UNDRIP. But for every day that there's an Indian Act, there legally and constitutionally cannot be gender discrimination. So they should seek an extension and do this right.
Yeah, we agree. I mean, it makes sense to have an extension. As has been said, 2 were granted in McIver. The judge in Deschanel specifically directed that there needed to be a broader fix by the government, that they shouldn't do another piecemeal fix as they did in 2010 after McIver, and that they need to get it right. And we understand that the litigants in Deschanel agreed to that. So there are a small number of people within Quebec who would be affected by the delay. Not across Canada, just in Quebec, which the government itself has testified at the UN CEDAW committee to that effect. It's a small group of people who would have to wait a little bit longer, but it would be for the broader benefit of women across the country who are being continually discriminated against. And it's just ridiculous that we're 50 years in on this stuff. So we certainly agree that a small delay in order to actually fix the problem is warranted.
The CBA Aboriginal Law section hasn't taken an official position with regard to the question of an extension. So what I can say is there are pros and cons to an extension. The Supreme Court of Canada recently, in the Carter case, commented on the very exceptional nature of extending a suspended declaration of invalidity. We do know it was done twice in McIver. There were criticisms made by the Court of Appeal in that case for doing so. But to the extent that court deadlines sharpen the government's attention, but I mean, the concern becomes if it's a further 6 months, then the substantive discussion only starts in month 5. How much further ahead has the discussion really been, as opposed to having a bill pass and then a commitment to have a further one by a certain deadline? And that's the motivation behind the recommendation the subject matter come back to Parliament, either committee of the House or the Senate, within 18 months.
That's 7 minutes. Thank you very much. Very well timed. The next question is from Romeo Saganash, please.
Yeah, thank you, Mr. Chair, and thanks to our panelists. I felt a certain malaise when dealing and discussing this issue. I certainly feel it as an Indigenous person, and I've expressed that preoccupation and concern in this committee because this process is so unprincipled and not based on human rights or the UN Declaration on the Rights of Indigenous Peoples. And essentially we're being asked to try to improve on a fundamentally racist and discriminatory legislation. And this legislation would just carry on as racist and fundamentally discriminatory, if I hear you right. So the other aspect, the other difficulty I have as a member of Parliament is throughout, in this mandate, as a member of Parliament, I also have a duty to uphold the rule of law. And upholding the rule of law means respecting the Constitution, which includes the Charter, by the way. And so in that sense, I would have a very difficult time to stand up and support this bill because of that, because it is still discriminatory. It is still, if I used one of the words that was used here, under-inclusive and discriminatory. So there's a huge problem here. And I understand the constitutional issues that were raised and the legal issues that were raised in this during these presentations. One of the other aspects that I would like to hear you on is this bill stems from the Senate, an unelected body, which has no historic relationship with Indigenous peoples in this country. That relationship belongs under the Royal Proclamation and treaties to the Crown, represented by the Prime Minister, who promised, by the way, a new relationship, who promised, by the way, the implementation of the UN Declaration on the Rights of Indigenous People. So any new legislative initiative should be based on those principles, in my view. This is not happening. At the very least, it should have been the Minister of Aboriginal Affairs to introduce this bill. And that's not where we're at. So I'd like to hear, because I basically agree to most of what was said here, and I'm in favor of an extension so that we can do this right, because that is the basis of respect, in my view. And additionally, the promise or commitment in the phase 2 coming up by the minister, well, it so happens that after a year of this government, I don't really trust those kind of commitments anymore. I don't really trust the promises that are being made by this government. So I'd like to hear you on those, on that strange process that we're following here, that this bill coming from the Senate. Anyone?
Go ahead.
Yeah, thank you very much, Mr. Saginash. You know, one of the things I find really difficult is to bring in the human aspect of this, because I know some women who have never been able to go back to their communities. It disrupted the family unit, and it's, you know, the Indian Act is not just an act in Canada, it's a racist act, it's a colonial act. It's about Canada's imperial history with Great Britain, and there's no reconciliation in this act. So I agree that this needs to be done right. There needs to be a portability of our rights. It's not just those living in the community, but the portability of our rights. And, you know, people talked about being inclusive. Having a right to vote in a band council election doesn't mean you're part of a decision-making process. So it's really, it goes much, much more deeper. And so the issue of status is really about you're supposed to uphold the honor of the crown. You're supposed to be respecting the rule of law, and Canada has signed many international covenants respecting the human rights as universal. Do the right thing and make the kinds of amendments that will finish this issue so we can go on to the other issues of land dispossession, threats to our language and culture, and all the things that make up our Indigenous identity, and so we can protect the land for future generations. Thank you.
I agree with you about the character of the Indian Act, and I also feel, as a settler, an identity that I acknowledge, I feel a sense of shame that we are still working on this, and that it is occupying the time of Parliament, and that it is occupying the time of Parliament to drop a thimbleful here and a thimbleful there, instead of doing a principled reconstruction of our relationship with First Peoples. It is more than high time that this should happen. But in the midst of that shame and in the midst of that great dismay at what use we are making of our institutions, I remember what the Indian Rights for Indian Women organization said, and that is they want this to be fixed so that the women and the children are back in the Indian band communities, the Indian Act, because it is only then that they can sit at the tables for the consultations that will determine their future. If they are not at the table because they are not status, they can't discuss land claims or anything else. As far as the Senate is concerned,
Just
I
1
think
minute
you've
remaining,
put your
please.
finger on something very dangerous, and that is someone will challenge this bill on that very ground after you've all labored to pass it, and then it will be blown out of the water because it was started in the Senate.
I agree with Ellen and Mary, and I would just throw it back to you a little bit and say Canada's Minister of Justice has certified that this legislation is charter compliant, and you have heard consistently, as has the Senate, that it is very obviously not. That should concern all of us, that we're here doing this. And the other thing that I would mention very quickly is Canada allows into Canada, either by birth or by immigrants, 650,000 new Canadians every year. And not a question is asked whether Canadians should be having any more babies or whether we should cut off the babies of just Canadian women.
Thank you. That's the end of the time for that question. The final question will come from Joelle Lightbound. Please.
We're at 4:30 with the minister here. Does that allow us time procedurally to continue?
With the committee's agreement, I was going to allow for the final question in this round and borrow a little bit of time from the minister in the second hour. We don't have agreement for that?
No.
Okay, well, I think I would need unanimous consent for that. So I think that we've heard our last question. I want to thank each of the people who have testified today. Thank you very much for your very thoughtful and powerful testimony. Very helpful to us indeed. And we'll take a short suspend while we switch panels. Thank you. Reconvene. Okay, we'll come back to order and commence our second panel, which is comprised of the Honourable Carolyn Bennett, Minister of Indigenous and Northern Affairs, and INAC senior staff. Welcome. I think we all know the rules by now, so I'm just going to turn the floor right over to you, Minister Bennett, for 10 minutes.
Thank you so much, and it's pleased to be back to discuss S3, acknowledging that we're meeting on the traditional territory of the Algonquin people. I appreciate this opportunity to meet with you to explain the government's proposed approach to dealing with the Deschanel decision. I'm joined by Indigenous Northern Affairs Canada officials, Joelle Montminy, that I think you know as the Assistant Deputy Minister, Resolution and Individual Affairs, Natalie Neptune, the Executive Director of Indian Registration Integrated Program. She is the Indian Registrar. We are trying to put her out of work, right? We are trying to get this business returned to First Nations themselves. And Candace Saint-Aubin, Executive Director, Resolution and Individual Affairs, from the Department of Justice, Martin Rear, General Counsel. So firstly, I want to pay tribute to the many courageous First Nations women whose tireless work brought these matters to light. Women like Mary Tuax Early, Jeanette Corbier-Laval, Yvonne Bedard, Senator Lovelace Nicholas, and Sharon Donna McIver. We'd also like to recognize Stéphane Deschanel, Susan Yantha, and Tammy Yantha, whose courageous fight will eliminate the discriminatory treatment of tens of thousands of people. Je tiens à remercier la comité pour l'immense travail.
I want to thank the committee for your tremendous work on this bill under challenging circumstances.
During their study, for which we thank them. Hearings at the Aboriginal Peoples Committee have identified one further group who should be included in this bill, and I believe will be included through an amendment introduced in the Senate. Meeting the court deadline of February 3rd required us to make difficult choices about the scope of the bill and to balance the necessary time for engagement with Indigenous people and that for parliamentarians to discharge your responsibilities. The Prime Minister and this government have committed to renewing the relationship between the Crown and Indigenous peoples. This means, whenever possible, working in partnership to resolve issues outside the courts. This is why the government decided to withdraw the appeal of the Deschanel decision, which we inherited when we came into office, and move immediately to remedy the inequities highlighted in that decision, as well as other known sex-based discrimination within the registration under the Indian Act. There's no question that the complexity of the issues that had to be remedied, combined with the court deadline for legislation, significantly limited the government's ability to engage with First Nations. Mistakes were made, including my department's failure to directly engage with the plaintiffs, and I've taken action to ensure that does not happen again. I've now personally spoken with each of the plaintiffs and committed to them that they will be meaningfully engaged as we move forward in designing the process for Stage 2. Despite this, I still believe that passing the reforms contained in S3 and proceeding with a more broad-based collaborative approach to address other more complex issues is the fairest and most responsible way to proceed. Nous devons mettre fin avant l'échéance.
We need to remedy these sex-based inequities before the court-imposed deadline.
But up to 35,000 other individuals who are currently being denied their rights. Witnesses have argued that this bill should simply be amended to deal with other potential forms of discrimination. Addressing other issues related to potential inequities in registration would have profound impacts on Indigenous communities. We all know that repeated unilateral decisions made by the federal government regarding Indigenous peoples have often had disastrous unintended consequences. Dealing with the issues raised here will require extensive consultation with communities about the impacts far more complex than just ensuring adequate resources. But fundamental issues, such as the cultural integrity of communities, le Premier ministre et le gouvernement ont clairement.
The Prime Minister and our government have been very clear that to achieve our shared goals, Canada and Indigenous peoples must work in partnership to build consensus and jointly develop solutions.
We have implemented a two-staged approach in our response to Deschanel. A number of witnesses have also suggested the solution to the limited time for consultation is simple: request a court extension. While I understand the preference to deal with all of these important issues at once, this is simply not an option within the time provided by the court, even with an extension. The length of any such extension would be extremely limited, effectively 3 to 6 months, taking into account the cabinet and legislative processes that would be part of that extension. It would provide minimal additional time to consult. In fact, it's very likely that at the end of the process, we would have the same bill before Parliament with little or no change. I understand the cynicism of Indigenous people and parliamentarians about whether the government will follow through on stage 2. Even if we do, whether it will lead to meaningful reform. Les gouvernements de toutes les
Governments of all stripes have failed to follow through on such promises for decades.
Launched in February 2017. This process will not only be jointly designed with First Nations, but will include the input of experts and those who have had rights denied by this archaic and colonial system. I can assure you that we will include truly inspiring individuals like Sharon McIver, Jeanette Corbière-Laval, and Senator Lovelace Nicholas. Stage 2 must engage with a broad group of people to ensure future attention is informed by perspectives from everyone who may be impacted. There will not always be consensus, and the government may need to make tough policy decisions in the interest of protecting rights. But those decisions will not be made unilaterally without the input of all those affected. However, I urge you to support the current bill and provide immediate justice for up to 35,000 impacted people. I would also draw your attention to witnesses such as the Congress of Aboriginal People, the Native Women's Association, and Jeanette Corbière-Laval, who have said that S3 should be passed. I commit that immediately after this important step, we will move forward in partnership and in a good way to achieving broader reform together. That would be the policy reforms that are required. In your own words, final goals, we will, as I've said, put the registrar out of work. Thank you, Miigwech. Merci beaucoup.
Thank you, Minister Bennett. We'll move right into questions then. The first is a 7-minute round, and the first question is from Mike Bossio, please.
Once again, as always, Minister, we thank you for making yourself available many times in front of this committee. We really do appreciate it. We just heard from a number of witnesses that came forward and felt that one of their chief recommendations was to make all Indigenous peoples 6-1A all the way is what they phrase it as. Eliminate all remaining gender discrimination by eliminating any differentiation in status between Indian women and their descendants and Indian men and their descendants born prior to April 17th, 85. Can you comment on your thoughts on why we can't immediately move in that direction?
Well, I think what we've tried to do in the bill right now is we have a legal obligation. The court has told us that this is discriminatory and against the Charter. And so we decided we would fix that. And we also decided that we would include the very simple ones that are clearly sex-based into this bill. And that's how we get to the 35,000. The other cases that are complicated by date of birth, or that there wasn't a registry before 1951, that there are other ones that are not sex-based, we believe, and because they may well win in court one day, but at the moment there's no court decision to. We want to go out and consult to see how you would do it. How do you even do the ones where there wasn't a registry before? Because asserting rights, it doesn't necessarily mean you have rights. It means that because rights have to be determined amongst people, and that we will do what we know is right. But we've got to go and talk to the people who will be affected by this, and we don't believe that can be done in a parliamentary committee. We believe that as Canada, we have a responsibility to go and hear from people as to how they would see their rights being exercised, and so that's why we've taken this right from the beginning, a two-stage approach. We would do the things that were simple and that the court told us we had to do, and then we would go out and deal with the more complex ones, but in a timely fashion. And if you wish, as a committee, I would be more than happy to come back to the committee to update you on the work that we're doing as we move into phase 2 and as we come to really get rid of all of the discriminations in the Indian Act.
So phase 1 takes care of 35,000 Indigenous people immediately, or as quickly as we can register. The registrar can register them. But how do you ensure under phase 2 that it will be executed upon in a timely basis?
Well, that's our commitment, and I think that we, in going out in the preliminary conversations, we will need to hear from the people affected what seems like a reasonable time to them. We know that consultation is not consensus. We're not going to get consensus that everybody will agree, but we will need to go out in order to make a good decision, have heard what all of the opinions are, and be able to come up with the best possible legislation we can to get rid of these discriminations that still plague, First Nations, coast to coast to coast. And there are simple ones like enfranchisement. I mean, whether somebody's got a post-secondary degree and ended up losing their status, but then there are other ones that we will have to sort out how it's implemented.
And so I know you've come here many times, but you'd be amenable to coming back in 6 months, 12 months, 18 months, so that we can hold yourself and INAC accountable to the committee to ensure that this does continue to move and progress in a timely way so we can get these issues resolved?
Absolutely, and I think what I committed to at the Senate last week is that we would even come back early in the new year if we begin with a work plan in terms of what we've heard and what seems like a reasonable time frame, so that you would be involved in in the design and the time frame of phase 2.
So going to phase 2 then, how do you kind of see phase 2 evolving then? You've given us a little bit of a taste as to what, but as far as being able to deal with these complexities once again in a timely way, how do you see that rolling out?
Well, certainly the plaintiffs, the complainants have really articulated a real interest in being involved in that. They know that their fight has got 35,000 people through the gate now, and they want to be part of making sure nobody's left behind, and that and they want to make sure it's a reasonable time frame. They don't want it to go out for years and years. So I think we will figure out a work plan that's reasonable, but where the people most affected will be, they will have their say in the design of phase 2.
So how much time do I have? 2? Oh, okay, good. So I saw that for example, I've seen a list of the preliminary consultation process you went through with, the Assembly of First Nations of Quebec, the Native Council of Nova Scotia, the Native Women's Association of Canada, the Anishinaabe Nation, the Congress of Aboriginal Peoples, the Confederacy of Treaty 6, 7, 8. So there's a number here. How do you, not just focus. I guess what we're looking for is assurances that you're not going to just focus on some of the larger organizations where you can get a lot of ducks at one time with one shot, but are going to actually get out to some of the small, like we've met with so many individuals and smaller organizations that need that representation and to be a part of that consultative process.
No, we've heard that in so many things that the national organizations have important people there with policy, but what we've heard very clearly is that people want us to be able to talk directly to the people affected, the communities, the community organizations that are the most affected, and even in Mr. Deschanel's own community, there are many people who will be left behind as S3 goes through, and just really talking to those people I think are going to be very important in actually hearing what they have to say, such that they don't have to go to court to get their rights. That we want to make a good policy decision that will get rid of all of these discriminations and inequities that are still in the Indian Act.
Sorry, I'll have to leave it there, Mike. Beg your pardon. Next question from Kathy McLeod, please.
Thank you, Minister. And just want to start, I note that last week you told the Senate Aboriginal Peoples Committee that, quote, my department's failure to directly engage with the plaintiffs was not only unacceptable, but embarrassing for me as a minister. But of course, as we all know, with all due respect, that as a minister, you're responsible for the department and what happens. And to be frank, I believe that you would have been outraged as a critic had we moved forward with a piece of legislation that clearly had so many flaws. And clearly, I look at the consultation. This bill was introduced on October 25th. Most of these consultations happened after the bill was introduced in Parliament. Some of them happened just prior, so certainly anything that was in their consultations clearly didn't see the way into the legislation. You have a big job with the second phase, and the big job with the second phase should really be about moving beyond this whole bizarre registration process that we have. But we have a chance right now. We have identified, I think we've had really articulate witnesses. This is issues around a charter. This is basic issues. And I think we can get these problems fixed for once and for all in your phase two, rather than focusing on, continuing dealing with the gender inequity, can actually deal with what is most important to First Nations, which is moving on and past and out of the system. So I guess, first of all, how can you sort of justify presenting a piece of legislation to this Parliament when the consultations happen after the legislation was introduced? Certainly not consistent with nation to nation.
I think that's the reason that this is a phase one and phase two. Phase one is to deal with what the court told us we had to do. And we were able to include some simple parallel cases in that piece of legislation, and then we knew we'd have to go out and do all the rest. This is, with due respect, my department has had very little experience over the last decade going out and talking to people. With due respect, we're here today because the C3 wasn't consulted on properly, and so therefore that is what we're having to turn around. We have to turn around a culture where actually the solutions are found by the people who know the most, those with expertise and those with lived experience. So that's why we're here today, is because C3 was flawed.
So what we have is we've had clearly witnesses that have come who have given us really easy diagrams to sort of figure out, here's the flaws that are still here. You talked about people that supported in a quasi way, if you read their entire testimony, moving forward right now with this flawed piece of legislation. But of course, we didn't talk about, the Canadian Bar Association, the Indigenous Association, Stéphane Deschanel. We just had an excellent panel of witnesses, and I think almost without exception, They said we can get this piece right and we can do it in a reasonable time frame so that we get rid of the things that are charter non-compliant, fix the flaws, spend phase 2 on the important work of moving forward. So what are you saying to these almost without exception expert witnesses that we've had at committee that have said, take a little bit more time, get it right, McIver had 2 extensions, we can do it?
Unfortunately, the court didn't give us more time. The court gave us a little bit more time because of the election, but we only had 18 months instead of the usual year that they give, and that they have said by February 3rd, the registrar will not be able to register more people because these provisions have been struck. Since this legislation came through, we have got, I think at the registrar's office, at least 100 to 150 more applications to actually be able to exercise their rights. So this is 35,000 plus people learning about it and coming to terms with it, and that's why we then need to begin phase 2 in February to deal with all the other ones.
So first of all, McIver did have 2 extensions, and to be quite frank, I think if you have a limited phase 2 that's dealing with things that we've seen at committee already, we are never going to get to the big conversation. I'm not sure how
we can't do phase 2 till we've done phase 1. I'm not sure what you're saying. Just tell me what you think we should be doing.
What I'm saying is we have some clearly identified charts and flaws. I think with technical expertise, you could identify any remaining that are charter non-compliant, and phase 2 can be the bigger, important discussion that needs to happen. Not, taking the Stefan Deschen's Mr. Deschenaux's lawyers' diagrams and spending, 2 years, 5 years looking at diagrams and talking about diagrams with clear flaws. That's my time.
I mean, I wish it was that easy, that there would be clear advice on the other issues of inequity. Unfortunately, the pre-1951, there wasn't even a registry then. The unknown parenting paternity is difficult to sort out. These are not easy things to implement, and you actually have to figure out how you would do it if you're going to draft a bill.
But there's still a number of issues that have pointed out that are known currently that we have not dealt with in terms of this particular piece of legislation. And I would suggest that when you see good motion towards getting something done, the courts have tended to be relatively accommodating. And in the case of McIver, there was 2 extensions granted in terms of that particular piece.
My advice has been that the extension would only be 3 to 6 months, and that the court is granting extensions generally to deal with the issues of the plaintiffs in the course. That in the inobiter part of the judgment, we feel we've dealt with the easy parts in this bill, but we believe that the judge's advice to us was to take proper time in phase 2, and we see that all as a piece. There'll be the easy things that we're doing right now that the court found as an inequity, and then we will get on with phase 2 in a timely manner.
Again, suggested that would be a process forward. Thank you.
We're out of time there. The next question is from Romeo Saganash, please.
Thank you, Mr. Chair, and thank you to the Minister for appearing before us again. I have several questions after listening to you, but let me start with the easy one. You said in your presentation, I'm giving you my word that stage 2 will be launched in February 2017. That's pretty close. So I imagine that you've already started a meeting with people on that and how this is going to be structured? Yes?
Yes.
Okay.
I mean, meaning that we are working on a work plan and deciding who we would talk to first.
Who are you consulting right now? Who are you consulting right now?
Who are we?
Consulting.
Well, I can...
Yeah.
Yeah, sure, please. Can.
Thank you for the question. So what we've done is we've tried to always prepare and inform people, that stage 2 was on its way when we were doing information sessions. We've reached out to the Assembly of First Nations following their presentation here, and we're trying to establish a time to start some of the pre-engagement conversations. It's always been part of our plan for stage 2 that we would do pre-engagement more broadly. However, hearing from witnesses in the past few sessions, we're looking as well to guidance on who should be a part of those conversations for pre-engagement.
Thank you. One of the things that I asked that question, Madam Minister, because February 2017 is pretty close for me, and in that sense, I kind of wonder because I notice how a snail's pace the Human Rights Tribunal decision is being implemented on by your government. You know, after one ruling by the Canadian Human Rights Tribunal, two subsequent orders, we're still not where we were supposed to be in that decision. So, that's why I'm asking if you're going to move fast on this one. The other thing, my problem with this present bill, and I want to get to Mr. Reither on this one afterwards, but the first one is you're asking us, and there's been consensus by all panelists and witnesses on this question, there's consensus that this proposed bill from the Senate is still discriminatory, still not charter compliant totally, and you're asking this committee, the members of this committee, to stand up and support this bill. You're asking me to go against my duty as a member of Parliament to stand up in that House and not uphold the rule of law. Your colleague, Mr. Carr, has certainly a different understanding of what the rule of law is. He's thinking police. I'm thinking something else here. The rule of law, according to the Supreme Court of Canada, is upholding the Constitution in this country. And in that Constitution, there's the Charter of Rights and Freedoms. And in that Constitution, there's Section 35 rights, Aboriginal treaty rights in that Constitution. So you're asking me to do contrary to what my duty as a member of Parliament is by suggesting that I get up in support of the S3.
I take a different view. I think that that when the Indigenous Bar pointed out this extra group that needed to be in the bill, we believe there will be amendment, and with that amendment, our advice is that the bill is charter compliant, and so we are obviously working on all the policy pieces to get rid of these other inequities in the Indian Act. And so that's why we've had to do it in two phases, so that we do what the court told us to do, added a few more simple ones, and now we'll get on with the more complex ones that deal with date of birth, deal with lots of other inequities that have been pointed out here at the committee.
I also want to understand what you mean by, you said, I think in response to one of the earlier questions, that we cannot make consensus. Everybody will not agree. Well, I'm sorry, because human rights are not negotiable.
Oh, no, I agree. But as we know, with overlap, with many different, there's an interpretation of rights, and an assertion of rights isn't necessarily the rights, meaning whether it's paternity that's questioned or whether it's other ways. We've got to figure out how we make sure the people who have the rights get to exercise those rights, and that means an integrity to the system.
There's still about 3 minutes left.
2 minutes.
2 minutes. Okay. I want to get to a question that I asked to the earlier panel, to Mr. And ask a question to Mr. Reither. I raised the issue about this bill stemming from the Senate, and given the fact that the Senate does not have a historic relationship with Indigenous peoples, I see a slight problem there already. The profound relationship that we have with Indigenous peoples belongs to the Crown. This bill should have been presented, if not by the Prime Minister of Canada, at least by the Minister of Aboriginal Affairs. Do you see a problem with that?
No, if I understand Thank you for the question. If I
I
understand properly,
don't know if you heard the earlier response to that question, that somebody might raise that very important constitutional issue, and it's going to be blown out of the water, were the words that were used in that response. I think the minister heard it when she came in, but I want to ask you the same question.
Just 1 minute remaining, please.
thank you. If I understand properly the question, it's about who was introduced legislation in the Senate. To me, that's a matter of parliamentary procedure, and I'm not aware of a constitutional problem that has been raised.
You've got 35 seconds.
35 seconds. I'll just ask the minister if she's aware of the concluding observations and recommendations of the Committee on the Elimination of Discrimination Against Women, if she has taken note of the report, because the committee also has recommendations for the Government of Canada in that report that came out on November 18th, ironically the same day as the report for Val d'Or came out. Has she taken note of the report?
1 second remaining.
What report is that?
I think we'll have to come back to that answer, Romeo. The next question is from Gary Nandasangri, please.
Thank you, Mr. Chair. Thank you, Madam Minister, and your colleagues from the department. On November the 21st, at our first meeting, Madam Montimi was asked a specific question with respect to whether this piece of legislation addresses the issue of sex-based discrimination, and I think you're quoted as saying, "We're confident with these amendments we're dealing with all the known sex-based inequities in Indian registration." And then you go on to conclude that in terms of your specific question for sex-based discrimination, yes, this bill is addressing everything that is wrong. Now, since that time, I think in the Senate there's submissions made with respect to what the minister was just saying. Today, but 2 weeks later, can you categorically say that this particular piece of legislation addresses all known sex-based discrimination in the Indian Act?
Thank you. Yes, thank you. So when I stated that the bill was resolving all known sex-based discrimination, it was in relation to, of course, what the court has ruled to be discriminatory, so the issue of cousins and siblings. As you know, we have also added the issue of omitted minors or removed minors. What we have found through the testimony of the Indigenous Bar Association was that there was another situation, which is actually the result of the remedy that we're bringing vis-a-vis the siblings issue. This then creates a new comparator group, and depending on certain circumstances, and it's quite complex, this could also appear to create another inequity, which we've looked at and we are prepared to address if amendments is tabled.
So I guess my concern is, like, have we actually canvassed all the issues with respect to sex-based discrimination? I recognize that phase 2 will be going into much deeper study and understanding, but I think what concerns me is that with respect to the national ruling, there was a specific, while it's an obiter, I think the intent was to make sure that we're not going back to court on specific sex-based issues. And we heard from a very esteemed panel just before you who identified a number of compelling arguments. And I just want to make sure that the minister is seized of this, that the department understands that we are addressing all the known sex-based discrimination that is out there.
Yes, and I'm sure what you've heard from the witnesses prior to this are different situation of differential treatment, but not all differential treatment equates discrimination. So again, as the minister stated, there are a lot of different considerations that go into determining if something is constitute discrimination. In the context of sex-based discrimination, we're confident that provided that we address the amendment raised by the Indigenous Bar Association, we will have addressed this. There are other more complex situations where the discrimination based on sex might be combined with other things such as date of birth and family status. For instance, I don't know if the previous witnesses have raised the issue of the pre-1951 cutoff. This is mostly a date of birth issue, and depending on the actual situation that is concerned, could also have some other related sex-based issue. But it's not strictly a sex-based discrimination. And in this case, for instance, in the McIver decision by the British Columbia Court of Appeal, it has been found that there was no need, that the government did not have to remedy situation pre-1951. So it has gone to court, and the courts have ruled that, has rejected the argument of the plaintiffs in that particular case.
But I think that what we're saying, Gary, is that even though the court ruled that way, we want to fix this. So there are things that the court have told us we have to do, and then the reason the engagement needs to take place, or what are the other things people want us to fix, and such that we could finally end all inequities in the Indian Act.
Thank you, Minister, for the clarification. Because in my assessment, discrimination is discrimination. I think it's pretty clear cut. And when we're dealing with an issue of sex-based discrimination, whether it's intentional or it's an outcome of a specific set of guidelines that may have a discriminatory effect, I think it's nevertheless the same, right? So my concern really comes down to whether we should be expanding it even a bit further, or is this the bulk, or what the department has identified and that's supported by other stakeholders to move forward with this particular amendment, with the phase 2 being a much broader conversation on discrimination as a whole.
That's what we believe we need to do in the time constraint that the court gave us, that we need to do this piece now and then do the other one in a timely fashion to deal with all the others.
Okay, and Madam Minister, if I could just ask Council as well, and with respect to timing, I know that's come up a number of different times from witnesses, and there is precedent for going back to seek additional time. I know that was sought in McIver twice, if I'm not mistaken. What is the limitation in going back to the court to ask for more time?
Thank you for 1 minute remaining, please.
Sure. So it is possible for Canada to go back to the court and seek an extension of time. Now, in order to be able to be successful, from past experience, we know that we cannot go too soon. The government has to show that it did what it had to do and did best efforts to meet the deadline. Granting an extension. Granting a suspension of a declaration when legislation is declared invalid is a remedy, is something that the court will not do lightly. So granting the extension will not do lightly either. Actually, the Supreme Court of Canada in Carter this year, actually in January, set a very high threshold and indicated that it's only in extraordinary circumstances that such an extension will be granted.
And we're out of time now. Okay, thanks. We're moving into the 5-minute questions now, and the first such question is from David Udiga.
Well, thank you, Chair, and I'd like to thank the Minister for coming today to answer our questions. I find it quite disheartening when the department initially told us that they did extensive consultations. Then we learned that this wasn't necessarily true, because just after the department testified to this committee, we found out all of the witnesses afterwards weren't consulted. So when did you become aware of this?
Yeah, I mean, I think I had understood that the drafting of this piece of legislation was to carry out a court decision, and that there would be some consultation that would be done, but because of the time frame, and I think I was persuaded that the bulk of the consultation would take place in phase 2, because phase 1 was just doing what the court told us we had to do. And so that But when I realized that the plaintiffs hadn't been consulted, and it really was a mistake. There was a letter drafted that was never sent, and that I was actually really embarrassed and immediately called the plaintiffs and had a very good conversation about what they, this long fight that they've had, and so I must say that it happened to me once before, a decade ago, on the Quarantine Act, where again I realized that my idea of consultation and other people's idea of consultation may not be exactly the same. So putting sort of citizens and particularly in First Nations, Inuit, Métis people into the DNA of what is a meaningful consultation is something that we really have learned and we've got to get better at.
Okay, I'd like to reframe that. When did you realize that? Okay, don't you receive briefings from the department on a constant basis? And why didn't you pick up on the consultation process?
Yes, I mean, I think that usually the briefings are general in terms of the general level of consultations and what we've been hearing. I think in this situation, because it was time limited and was viewed to be really just executing a court decision, that probably I didn't ask as many questions as I should have about the consultation. But I do now understand that and had, I think, believed honestly in my heart that the real bulk of the consultations was taking place in phase 2.
Okay, Minister, we heard from a majority of witnesses that S3 is flawed. Will you listen to First Nations and ask for an extension, or will you ignore First Nations' request to have an extension requested?
Well, ignore is not exactly what I do. I'm hearing intently the concerns that have been raised. But I think there's been a misunderstanding about what an extension can do, and that the fact that this extension would only be 3 to 6 months, and there's no way that we could address all of the issues that have been raised at these two committees in that 3 to 6 month period. We would have to actually, in order to be drafting the new legislation now in terms of getting through the cabinet process to ask to do it and then go back with the bill and to be able to get it through both houses. So I think there's a bit of a misunderstanding as to what actually is possible in seeking an extension and why a court would give us an extension. I understand the cynicism is that people think this revision to the Indian Act is the train's leaving the station and how much can we get on it as it's leaving, as though we won't come back at it. And I think I'm here to say the meaningful consultation will start in February, and we will come back with a proper plan for that.
Thank you both. The next 5-minute question is from Don Rusnak, please.
Actually, Michael McLeod is going to take that.
Yielding time to Michael McLeod.
Thank you, Mr. Chair, and thank you to the Minister for presenting today. I think most of us that have been following the issue for years were quite pleased to see that the government was moving forward, moving away from the previous government position that they were looking at appealing this. And however, this issue is very complex, very, very complicated. And I come from Northwest Territories, and half of our population is Aboriginal. And we have 8 Aboriginal governments there. And we still have a lot of issues around who belongs to what organization. And we still have a lot of people that are being left out. I think at some point all our organizations will be self-governing, be under self-rule, and the Indian Act will no longer apply. We've already seen movement on clean show government and Delaney, the community of Delaney. But my concern is that if we don't do this now, it may not happen. We heard presentations today from a number of people that presented some very good research and very good arguments on why we should do it now. I mean, why we should defer it, and they talked about getting the bill right. And we also heard from some of our colleagues that said they don't trust the government. Well, I'm not sure what will happen in the future. I know there's 35,000 people that are looking for this to move forward, and that number may grow. So realistically, if we don't do it now, how long would you anticipate it's going to take to get it right, to deal with all the issues that are out there? And I can't say I know all of them. I'm not an expert in this field. And what do we expect that 35,000 people assessment to grow to? We're hearing it's already growing by 150 or more.
I believe, and you know my preference, is that we get this done now with the 35,000. This is serious in terms of whether it's health benefits or post-secondary. This is what we're hearing from people. They don't want to wait any longer. And yet what we are hoping for is that whether it's a year or 2 years to get the rest of these inequities dealt with in a bill, that we are committed to getting those done and getting it right in that way. We do not believe that we have time to deal with the inequities that are not sex-based in the time available, and that the court would give us sufficient time to get it right. And I think that you know, as most people know, I don't think parliamentary committees are the way the Crown consults. We actually do have to get out and do our work first and then bring it back to committee with hopefully all of these other inequities dealt with.
This issue has been causing a lot of discussion right across Canada, and I've heard from people in my riding, and I've heard from people that would like to look at this in terms of reconciliation. This is an issue that could bring us back all the way to when treaties were signed.
1 minute remaining, Mike.
When the script was imposed on people. And I'm not sure if that stage 2 will actually allow for that to happen. Is that something that people can anticipate to have the discussion go all the way back, in our case, to Treaty 11, 1921, and talk about, because even in my family, some people were allowed to take status, other people were not. I got cousins that are status, cousins that are not. And it depended on a lot of different things. So I'll leave it with you as a question.
Well, I think that's a great question, because I think the whole issue of membership and registration, we want eventually that to be determined by nations themselves, that this isn't something Canada should decide as in the way that the Indian Act was written, that we decide who has status and who doesn't have status. We want to get out of this business, out of this line of business, and that's why it's exciting to actually get it right. In what
Minister,
would that
we're
look
out of
like?
time on that one, I'm afraid. Okay. Next question from Kathleen McLeod, please.
Thank you, Chair. And so I'm just going to go back to your comment that committees, that you need to do the consultation, and then, the committees do their work and we're not the environment. And I absolutely agree. Unfortunately, we've seen with S3 that I mean, that's exactly what's happening. The consultation happened after the legislation was drafted, and it's come to, and in this case, luckily, it came to pre-committee simultaneously while it was in the Senate. And, you know, certainly the flaws are coming very much to light. And again, I look at Mr. Deschanel's lawyer with his 4 pictures of different very inadequate sort of responses of the legislation. But so we've had a committee, we've had expert witnesses, and the vast majority of them have all indicated that they believe there's still flaws. We're not privy to whether it will come from the Senate with a minor fix or not. But the advice to this committee by the vast majority of witnesses from across the country is take a little bit more time, get this right, ask for the extension. And so, so the position you've taken at the table today is you're not going to do that, so that what all these witnesses have said to us is something that you believe is not the way to go forward. Whether it was, National Chief Bellegarde, whether I can go through the list, and you've seen the testimony. So what you're telling us today is that you are really, it's very nice that they came, but we're going to go forward just as you sort of went forward with the drafting without their input. Is that what I can, that they're hearing today?
No, I think what we're saying is that if we were to ask for an extension, it would be in order to get the work of this bill through the 2 houses in a timely fashion. I think we do not believe we'd be granted an extension in order to deal with all the other inequities. So I think that is the advice that we've been given, that it needs to be about basically the ballpark of what the plaintiffs argued in order to seek justice for those plaintiffs. That would be the purpose of an extension. And so we're very grateful that because of the sibling issue in S3, that the Indigenous Bar pointed out this other group that will lend itself to an amendment. And with that, we do believe that we will have a bill that will deal with what the court asks us to do.
So I think on November 21st, and I'd quote, my question to the department was, the proposed amendments to Indian registration to comply with Deschanel's decision and to eliminate all known sex-based equities. And I asked if they were confident that we have taken care of this as an issue, and the response was yes. But we're hearing that the response should have been no, because the Indigenous Bar Association and others have said that it doesn't deal with all the known sex-based inequities. We've heard that from many witnesses, that does not deal with it.
I think what the Indigenous Bar pointed out to us is that the bill itself created a new group. So in fixing the other ones, we created a new group, and now that can be dealt with the amendment.
But I think, again, this is showing that with all, again, respect, that when you rush something and you don't talk to the people that are so knowledgeable, when McIver joined us, I mean, she had such knowledge that she brought to the table, and so I think there is misses. I think there's more misses. I think we've heard concerns from other witnesses, and if the amendments pass in the Senate, I still don't think, we're not going to be back doing this again through a court challenge, wasting everyone's time, energy, and muffet because we haven't got it right.
We're out of time there, Kathy. That's we're over 5 minutes.
Mr. Chair, if I may, just to say that is the good work of a parliamentary committee, to actually point out something that's been missed. That's what I really do believe is important, and somebody that comes with the remedy to fix it. So I want you to believe that this is the important work of parliamentary committees, but that we need to go out and consult in order to do the rest of the inequities.
Okay. Thank you very much. I wanted to say thank you to all of the witnesses, Minister Bennett, and your staff team. Committee members, I've intentionally left about a minute and a half. We have a short bit of committee business so I ask you to stay in your chairs. With Charlie Angus removing himself from our committee, we're left without a second vice chair, and it's our duty to elect Romeo Saganash. You have a Grant has a little bit of process. Grant has a little bit of process for us. So we just listen to Grant for a moment, please.
Pursuant to Standing Order 1062, the second vice chair must be a member of an opposition party other than the official opposition. I'm more than prepared to receive motions for the second vice chair.
It looks like Don Rusnak is making a motion that it would be Romeo Saganash.
I'll do Romeo.
And the second, Kathy McLeod. Okay. So there's more process.
Thank you for your patience. It has been moved by Don Rusnak that Romeo Saganash be elected as second vice chair of the committee. Is it the pleasure of the committee to adopt the motion?
We're agreed.
Thank you. I declare the motion carried and Romeo Saganash duly elected second vice chair of the committee.
Thank you. Motion to adjourn? We're adjourned. Congratulations, Romeo.